Hello, I'm Ajay Shah and I'm part of the team that has been building the Law, Economics and Policy Conference for many years now. What we try to do in each of these sessions is to pick some of the big issues of the age and try to get some of the best minds to come together and discuss these. There are few things more important to the working of democracy than the courts. I think it was Fareed Zakaria who said that the courts are even more important to democracy than elections. And this is really an incredibly important problem in India. Now, most of the time, the problems of the judiciary seem very large and very complicated, and you don't even know where to start. In this session, we've pulled together 3 tangible, specific questions that are contemporary, where many people have applied their minds, and it appears that we are on the cusp of important change in this regard. The first of these is about the role of tribunals and tribunalization of the Indian justice system. The second is about the idea of the National Tribunals Commission, the NTC, which would be both an administrative and a judicial operations agency that will run the tribunals. And the third is the question about hearings that are conducted inside regulators. These are specific, tangible problems where there is a good deal of understanding, and then there is a possibility of making incremental change. So I thank you all for being here with us today, and I look forward to having your enthusiastic participation in this session. Thank you.
Good evening, ladies and gentlemen. It's a matter of great privilege for me to welcome you all to this edition of the Law Economics Policy Conference of the INET. This evening, we have an erudite panel of speakers and discussants, people who've dealt with these issues in some depth and have great insights on the working of the institutions, and much more importantly, are people who are desirous of improving the working of this still emerging but important pillar of justice delivery. Within the broad topic of justice delivery new frontiers, the attempt this evening will be to cover 3 distinct subtopics. Subtopic 1 is the working of tribunals as a dispenser of justice. This is very sort of contemporaneously important given that the Parliament reenacted the Tribunals Bill in more or less the same form as it was passed earlier, very recently, a couple of days ago. This omnibus tribunals related bill has been controversial. Many of us are familiar with the details of this bill, but suffice it for me to say that there are huge pluses and minuses with this tribunalization effort, and the subtopic 1 will primarily focus on this aspect, the pluses, the minuses of this tribunalization effort, and what will it take for this effort to succeed. Subtopic 2 will focus on the judicial functions of statutory regulatory authorities. Though it's a distinct topic and a separate topic by itself, in a sense it is related to subtopic 1, and this is because on an average a lot of the current day tribunals tend to hear appeals from statutory regulatory authorities, And in many cases, bodies like SEBI and RBI from the financial sector, and there are similar bodies in other sectors, are in their judicial functions now almost as important as tribunals. The kind of judicial functions that have been entrusted to them, that are being discharged by them, not necessarily always with people trained in these functions, but nevertheless discharging these functions. This aspect of the functioning of SRAs, statutory regulatory agencies, statutory regulatory authorities, is the second subtopic. Management and administrative matters of tribunals is the third subtopic of the sort of broad, bigger topic. Though this sounds at one level something unimportant, something trivial, in tribunal after tribunal, these are emerging almost as showstoppers. These include, besides the much discussed, well known, larger topic of the judicial vacancies and the member level vacancies in the tribunals, the matters like non judicial support positions, court masters, stenographers, registrars, deputy registrars, a whole bunch of personnel related issues, physical premises, IT systems, etc. And there are recent judgments of the Supreme Court that have gone into these questions and proposed solutions like the National Tribunal Commission as the way forward. The eminent speakers that we have with us today will speak on these topics, and I will leave it to each of them to decide whether they want to focus on any one of the subtopics or would like to cover all three. These are experienced judges who've dealt with all these aspects, and I will leave it, as I mentioned earlier, to the individual speaker to focus on a particular topic. Likewise, the two discussants are very eminent senior lawyers who have many years of working with, appearing before various tribunals, and are therefore well placed to comment on all these three subtopics and the measures that are required to improve workings in each of them. On my personal behalf and on behalf of the organizing committee and the INET, I want to welcome all of you, madam and sirs, my panelists, speakers of this evening, and would like to thank you for taking out time to join us this evening despite many other commitments. It's equally my pleasure to welcome all the attendees in this session. The way I propose to conduct this is to call upon each speaker in the sequence mentioned in the agenda with a very brief one line introduction. Genuinely, none of my panelists this evening requires an introduction. So, except for very briefly inviting the speaker, I will not get into a detailed introduction. Each speaker will have 10 minutes in the round one, and I will alert, if you don't mind, when there are 2 minutes left, so as to ensure that you can then conclude and sort of meaningfully end your presentation. After we have all the three speakers, I will call upon the discussants in the same fashion. We've kept aside time for questions and answers at the end, and our team will be gathering these questions that the audience can send through the messaging system in the Q&A box, and then these will be passed on to me. And in the discussion session, I will, with your permission, madam and sirs, direct them if they are directed to individual speakers, or put it to the sort of panel for its response. With that, can I now call upon Justice G. Raghuram to deliver his presentation? Justice Raghuram served as a judge of the High Court of the Andhra Pradesh, the erstwhile undivided Andhra Pradesh High Court, and thereafter was president of the CESTAT, and then was director of the National Judicial Academy for many years. I've had the privilege of participating in many of the programs of NJA when Sir was the director. It's a privilege to have you here, sir. Over to you, and you have 10 minutes starting now. Thank you.
Thank you, Dr. Krishnan, and good evening to all. Uh, every one of the panelists, and I presume uh, many of the attendees, are conversant with the problems plaguing the tribunalization protocols in this country. Uh, to that extent, it's substantially a beaten track. The problem with our problems is not one of problems, but one of solutions. We are just uh, uninterested in pursuing the solutions to optimal outcomes. I was reflecting for a long time. As a brief intro, I may say that I've had substantially nodding acquaintance and occasionally more than nodding acquaintance with tribunals for over 42 years. Having appeared before tribunals in 79 and later being a part of one tribunal of a national dimension. Uh, over these years, from my experience and exposure to tribunals, I was reflecting, why is it necessary to have tribunals? The facial justification offered by academics and administrators uh, ad idem is complexity in economic, social, cultural, and administrative issues in contemporaneous social matrices. Then another justification, there are several, but these are the critical justifications that are offered. Overly elaborate rules of evidence and procedure operative in regular courts. And the third is excessive burden of caseload plaguing our court system, plus interminable appellate and revisional processes that we have. In reality, the court system overburdens, to, to my mind, are primarily due to inadequate judge strength, not necessarily in that order of priority, ill-equipped adjudicators, which again is a consequence of substandard recruitment and promotional protocols, inadequate training, and precedential incoherence and instability. All these contribute, and the last also makes a substantive contribution to the delays. Badly drafted legal rules and endless litigation is incentivized, of course, by those who can afford. Prolixity of pleadings and arguments and falsehood to authority and courts goes both unpunished or unpenalized. These are broadly the reasons why we have delays in the court system. Now, if we reflect on the broadly shared reasons offered for tribunals, then a judicial or administrative review, either before or after the creation of a tribunal, must positively answer the requirements why that particular tribunal is established. That doesn't happen. For instance, as I said, I've had nearly 4 decades of exposure and more than nodding acquaintance with certainly administrative tribunals, for instance. I found no justification for taking, service matters out of the court system. A judicial review would have sufficed. L. Chandrakumar only created a hiatus trial adjudication before the tribunal, and almost all the matters come to under 226. So that was a no-brainer in effect. And my experience as a litigator before the service tribunal was that more than 95% of the matters just require ordinary administrative law and occasionally constitutional law familiarity, nothing more. But nevertheless, you create a tribunal, and it's been my experience, at least in the administrative tribunal of one state, which is more than 4 decades old, in the state of Andhra Pradesh, that both in the choice of the judicial component as well as the administrative component, no care is bestowed to those familiar with administrative law or constitutional law. And a judicial officer who's might have had difficulty drafting his leave letter is appointed as a judicial member, for a service tribunal. That is absolutely defeats the purpose. Now, in the operative reality of a tribunal, assuming that the tribunal is justifiably introduced, today there is a lot of incoherence. I have not seen the provisions of the new bill because of my domestic preoccupation for a couple of days. There was a need for a nodal agency to cater to funding, to the structure, adjudicatory and administrative, and there's also a need for a regular audit of such nodal agencies' neutrality and professionalism towards the administration of the tribunal. There is an unstated assumption of the executive branch of favorable outcomes, particularly in regulatory and tax areas, that infests, if I may say so, the tribunalization of those areas. We have seen that in the income tax tribunal, where transfers and postings and constitution of benches was sought to be commandeered by one of the litigating parties, be it the state, but still a litigating party, representative in the executive branch. I know that in the indirect taxes tribunal that I was associated with, it didn't happen during my watch, but it occasionally happened before my tenure and after my tenure, immediately after my tenure. The postings and transfers of members, technical or judicial, was sought to be taken over by the executive branch. Now, that to any person, even vaguely associated with rule of law, would appear to be blasphemous if the very ministry, and unfortunately in that area, the very ministry which is formally a party in every litigation is also the administrative ministry of that tribunal. So if one of the parties can appoint and transfer, choose who is to adjudicate, I don't see in principle and jurisprudentially why a taxpayer shouldn't be able to choose a bench. So I find no distinction in degree in that problem. Another very disturbing fact I find, particularly in the last decade, is that invariably, or at least most of the times, an appeal is created to the Supreme Court. One consequence that I perceive of this is that you are disabling High Court judges of a domain familiarity and expertise in large areas, and you may pardon the choice of the expression, they'll sit as virgin adjudicators in the highest court on that domain, not having been familiar with the alphabets of that particular law or dispute area ever in their lifetimes, unless they have practiced in that area before coming on to the High Court bench. So that is one very bad outcome of creating appeals to the Supreme Court. There seems to be some fetish. I have a disturbing feeling, I hope I am wrong, and I sincerely hope I am wrong, that one assumption of the executive branch is that you will flood the Supreme Court with volumes and trivia, so that they'll not be able to seriously review any errors in a tribunal whose outcomes are commandeered by the executive branch. These are a few observations that I have, broad observations I have uh, of my over the years association with tribunals and tribunalization. Thank you. My time is up.
Thank you very much, Justice Raghuram. That was a concise but comprehensive sort of set of arguments on why fundamental basis of tribunalization itself is open to question. Thank you very much for that presentation, sir. It is now my privilege to invite Madam Prabha Sridevan. Madam served as a judge of the Madras High Court and thereafter as chairperson of the Intellectual Property Appellate Board, which is a tribunal that was constituted for matters associated with intellectual property rights. Madam, over to you now. Your 10 minutes start now. Thank you.
Good evening. Thank you, LEPC, for inviting me to speak about tribunals. Um, Dr. Krishnan said that we could choose the area that we speak about, and I am in accord with Justice Raghuram. I too think that I'm not a supporter of tribunalization. And I agree with Justice Rumapal, who said in her Tarkunde lecture that this was akin to Kalidasa sitting on a tree and cutting away. Um, though the 2 years that I spent at IPAB were most intellectually stimulating, and intellectual property law has actually caught me like the Vetal in the Vikram Vetal story, but I still do not support tribunalization. Just before this talk, I was looking at the websites of some tribunal, and one of them actually says it is a bull whack in dispensing justice. BULLWHACK, and I agree. It's not a bulwark. It is we, the people, who want justice, and we go to tribunals. In the first place, I detest tribunals being called quasi judicial forum, because whether it is somebody who's opposing the anti dumping duty or whether it's somebody protesting against some environmental horror, they want justice. They don't want three-fourths justice, right? And they want it to be delivered by a body which accords with the oath that we took when we went to the High Court. Without fear or favor, affection or ill will, uphold the Constitution and the laws. No tribunal is extra constitutional. It has to accord with the Constitution. This saga started with the 42nd Amendment, and slowly the diminishment of the space occupied by the judiciary began. Every tribunal is set up, if you see the object and reason, it is for effective functioning and speedy disposal of the cases. Then what is the subtext? The subtext is the jurisdiction already exercised by the courts till then was not effective. So there was a malady. And how do you rectify the malady? You have the channels and the arteries had to be cleared, not by applying temporary stents, which, in my opinion, was what the tribunals are. And if you see the commencement of each tribunal, you will realize it almost always is a knee jerk reaction. If you remember, in an international forum, India, Australia, they all said that we will create forums for environmental protection. And at that time, the Supreme Court asked, "What have you done?" And immediately the AG said, "We have created." How do you create? It's not like Moses saying the seas part. Infrastructure has to be there, people should be there, and it should be run effectively. As High Court judges, as my two learned brothers will vouch for, we are protected. Our only problem is deciding the cases. We don't have to deal with the rest. But as heads of tribunals, uh, I don't think there is any ministry that I have not stepped in the North Block or South Block during my 1.5 years at IPAB. Seeking pay parity for my staff, better infrastructure, better space to run my tribunal. In fact, Justice Nandarjog will know that it's because of the kindness of the Delhi High Court that we conducted our circuit sittings within the court. In Calcutta, we had to do it in the IP office. And even in a tribunal, justice must be seen to be done. And one side of our intellectual property litigation is always the controller of patents and trademarks. And we run the tribunal, we conduct our hearings between the corridors of shelves of patent claims. It hardly inspires confidence. And I had a personal experience of how suddenly it happens. I spoke of Moses. Justice R. Balasubramanian and I were hearing the Novartis case. It was split in two. One was the attack on the constitutionality of Section 3D, and the other was about the patentability of Gleevec. We had heard the constitutionality. We were just going to start the patentability. I think Mr. Santibhushan had begun his arguments. Suddenly, this act came, and the words say, "shall stand transferred to the IPAB." So it was just taken away from us like the baby in the Solomon story or something like that, and it went to the IPAB. And was the IPAB equipped to deal with important cases? Let me tell you, when I was hearing, when we were hearing the Combigan case, the Pegasus case, even if we adjourned a matter, it got reported overseas. So the issues that the IPAB hears have that much importance, and without any infrastructural facility or any other kind of support, the IPAB was started. Fiat lux, and then there should be light. This is how practically every tribunal is started. And now let us look at the composition of the bench. They're supposed to be judicial members and technical members. Now, I have an interesting quote from Peter Prescott, QC, who talks about what the words technology and technical mean. He says, "The hard truth is this: concepts of that sort have no existence, and words of that sort have no meaning except by human convention. And it is precisely at the margins of uncertainty that cases come up for decision. The same goes for the cognate word technical." And he says that the most informed respondents agree that trying to define the words technical and technology is a dead end. And I mentioned Justice Romapal's lecture. She observes that a more serious inroad into institutional judicial independence would be hard to find. And she is referring to the presence of technical members. In the case Northern Pipeline Construction Company versus Marathon Pipeline, US Supreme Court, the constitutionality of the Bankruptcy Reform Act was challenged. The plurality opinion of the US Supreme Court suggested that Article 3 commands who shall exercise judicial power and that there were three exceptions to this. And what did not fit into those pigeonholes was unconstitutional. Lawrence Tribe says the plurality laid down no unifying principle. There is no reason to assume that the laundry list of acceptable non Article 3 courts is exhaustive. And the sprouting additions, he says, will effectively eviscerate the constitutional guarantee of an independent judicial branch. So we have technical members who are bureaucrats drawn from the service, and we have judicial members who need not be equal to a high court judge in some cases, dealing and deciding issues which were hitherto done by the high court. Judicial review and remedy are fundamental rights of the justice of the citizens, and there cannot be any short change of this. The growth of tribunals has been haphazard without any overarching plan, and the insulation. When you talk of insulation of judiciary, the members of the tribunal should be equally insulated. As regards speedy disposal, just recently Supreme Court spoke of the vacancies and said if you cannot fill it up, just close the tribunals. I think tribunals have overstayed their welcome, and I would be glad if the jurisdiction is restored to high courts. Thank you very much for giving me this opportunity.
Thank you very much, ma'am. That was again another very comprehensive statement of the lack of effectiveness as well as sort of fundamental issues relating to the tribunalization question. Thanks very much for that very articulate presentation. It is now my privilege to call Justice Pradeep Nandrajog. Justice Nandrajog till recently was Chief Justice of the Bombay High Court, and prior to that, Chief Justice of the Rajasthan High Court. Before that, he was a judge at the Delhi High Court for many years. Over to Justice Pradeep Nandrajog. Sir, your 10 minutes begin now, and I'll alert you when you have 2 minutes. Thank you.
Thank you very much, KP, for having given me an opportunity, though brief, to pen profile my views. And after Justice Raghuraman has spoken and Sister Sridevan has spoken, the bonsai versions which they have put leaves hardly much for me to add on. But when we say that the time has come for the tribunals to be wound up, we must keep one thing in mind, that even when it comes to court adjudications, from the cries which we hear from the consumer of justice, when I mean consumer of justice, those who have a stake in whatever is being decided in the courts, there is a cry for specialized benches in the courts itself. So whether you have a specialized bench in the court or you have a specialized bench of a tribunal, it's the two sides of the same coin. We have now, when it comes to commercial litigation, commercial divisions in the courts, the Delhi High Court has now said that there would be an exclusive IPR bench. So whether that adjudicator sits under the umbrella of a court or that adjudicator sits under the umbrella of a tribunal, according to me, makes no difference. Meaning thereby that the cry is for specialization. You need specialists. Having said that, then we come to the point of the adjudication by the specialists? Should we have a technical member? Should we have a judicial member? And let me tell you that this concept of a judicial member as understood by a judge, as is commonly known, is also a big myth. Before the economic activity took over in this country, let us not forget that 50% of the civil litigation was revenue related. If we could have the revenue assistant who was a bureaucrat, if we could have the appeal being decided by the collector, and if we had the second appeal being decided by the financial commissioner, none of them were judges. They were experienced people who had operated on the floor of the factory. They had seen how a raw iron is forged. They were better at adjudication. And some of the finest judgments which I still find on revenue laws are by the financial commissioners. We had ICS judges who were not judges by training. Excellent judgments. Therefore, this division which we tend to create and say that it is so important is on the belief that a judicial member would bring impartiality, would bring in more confidence to the consumer of justice that here is a person who would not be influenced by the executive. We talked about transfers. Well, are transfers not taking place in the high courts? Don't we get to know that when it comes to the district judiciary, suddenly orders are passed by courts and next day there's cry in the press that such and such judicial officer who was at a very crucial stage of the trial has been posted out? In those transfer postings, I don't think so the executive has any role. And as Justice Raghuraman rightly said, the problem is not to identify the problem is to solve the problem. And to solve the problem is very simple. You need people with spine. Let us say if there is a tribunal where every member of the tribunal has the same spine, there would be no scope of bench hunting. There would be no scope of any kinds of transfers. So first and foremost, I find nothing wrong in tribunals. If the cry is for specialized divisions in the courts, it makes no difference whether the umbrella is of a specialized tribunal. The point is we need people who are specialists. Do not forget, whether it came to sugar control orders, drug control orders, fixation of electricity tariffs, which was considered to be legislative functions, they were always done by technocrats and bureaucrats. Nobody raised a hue and cry. Just because the economic scale has gone up now and we feel more competitive about it, nobody raised this issue as to how the electricity tariff is being fixed by the State Electricity Board, comprising of whom? We never raised those issues. Why are these issues being raised now? Because nobody doubted the integrity of the people then. So the ad base, the problem is to find a pool of people who are not only talented, would sell their talent for a price, that is to say, accept a tribunal for the benefits of the economic benefits of the tribunal, but would never let anyone put a price on their soul. Having said that, we come to the next issue. What's the point in creating a tribunal when you cannot provide it with an infrastructure, you cannot provide it with the manpower? But the same thing applies to courts. We cry day in and day out that we don't have the requisite infrastructure for the courts. We don't have requisite staff for the courts. As a senior judge of the Delhi High Court and as Chief Justice of 2 Premier High Courts, we had instances of 1-1 stenographer being shared by 2-2, 3-3 judges. We have public prosecutors attached to 2-2 courts. So whether you have a tribunal which is not properly staffed, or you have a tribunal which doesn't have an infrastructure, what difference does it make if you have a tribunal which doesn't have and a court which doesn't have? By no means am I to say that have a tribunal which doesn't have an infrastructure. So the only way out, the only way I feel, is to have an independent body which will make appointments. Like we have an independent body, the collegium system, and the High Court making appointments for the district judiciary. So create a body which is free from executive interference. And it is that body which should be then charged with making appointments. Yes, a minimum amount of budget is required. And let's put an electricity regulatory authority. Why can't a particular fund be generated and loaded onto the tariff? We had the tribunal headed by Madam. All those who were in those tribunals, there were stakes involved. Why cannot the fees, the court fees, be increased so that the tribunals are self-generating on their funds? So we have to think out of the box. When we talked in terms of support staff outside court management and all, let's understand. Court managers have been there in courts for the last 15 years. Nothing has happened. Every court, like for example, where there is trial work being done, Delhi High Court, the management part was handed over to the registrars, joint registrars, deputy registrars. So we had that. Yet we failed in the endeavor. And the point is that you have to have people with commitment. Let's not forget, when we look at the data, when we say that we have inadequate judges here, before we talk of that, we must look outside and see what is the disposal rate of judges abroad. From one of your research papers on your organization, I saw that the average disposal in the district judiciary in Australia is twice of that in the Indian judiciary, subordinate judiciary. We have to seriously look into that. We seriously have to look into that. When we talk of infrastructure and money available, we have to keep in mind that the government has to spend on schools, on colleges, on maintenance, new bridges, new roads, new airports, new dams. You need to have more power generation plants. So we are not going to have that kind of luxury of the money which we expect. And number two, if you have to say, I'll solve the problem if you give me this support, well, you don't have to think like that. You have to say, what can I do internally? And I think the only way forward is to have a body to make these recruitments. The recruitments would be of people who would be independent. If the panchayats can sit in the village square under a tree and dispense justice, well, why can't a judge or a tribunal also sit under a banyan tree and dispense justice. You don't need a courtroom. You can sit with your computer and a Wi-Fi system dongle. You don't need a optical fiber. You don't need that. So let's be innovative about it. Let's accept that it is the area of specialization. So therefore, I beg to differ from what Justice Raghuraman and my sister said. When we talked of the administrative review jurisdictions of the High Court, as Justice Raghuraman talked about L. Chandra Kumar and Sampath Kumar, well, L. Chandra Kumar was the right view. But what happened? The Supreme Court got inundated with SLPs from the tribunals. You didn't have the right people in the tribunals. And the Supreme Court said, what do we do? So they said, okay, let it give it back to the high courts. And then you gave contrived jurisprudence. You gave a contrived jurisprudence to confer it back to the high courts. Just like I said, if the financial commissioner exercising a revisional jurisdiction, he's also exercising revisional jurisdiction, which is akin to a review jurisdiction, like an administrative review jurisdiction. If he could do it, why can't the appellate bodies over decisions of the primary authorities do it? And let's understand, KB, you've been in the bureaucracy. When it comes to service matters, don't you hear service appeals? Don't you look at the reports of the inquiry officers? And many times you disagree with them. Many times you disagree with them. So let's understand that over the years, the bureaucrat builds probably a greater experience than a judge. He lives through it on the floor of where these disputes fester. I have full faith. I have full faith in the ability of even the executive, provided you have the right man on the right seat. I would have full faith in the judiciary, provided you have the right man on the right seat. So it's all a matter of right people to choose the right people. And once you've done that, the problem is solved. Yes, when we talk of the various adjudicatory forums, I'm reminded of Krishna's chariot with 5 horses. So we also have those 5 horses, the traditional courts, the tribunals, the mediation, arbitration, and conciliation. So all of them have to run in tandem. It's like on a chariot, if one horse is running too fast, he'll trip the others. So when you look at these broad pictures, time is short, but it is quite possible to do it, and let's accept it that specialization has to be accepted. We cannot do away without specialists. With that, I would like to conclude.
Thank you so much, sir. Essentially, sort of bringing the debate back to a debate, go to the root of the issue, competence, integrity, independence, and not the forum, and effectiveness of the judiciary itself. Very, very fundamental points. Thank you for injecting a different viewpoint, and I'm sure a viewpoint based entirely on your appreciation of these realities on the ground. Thank you for that presentation, sir. It is now my pleasure to call Harish Narsappa. Harish is a partner in Samvad Partners and the co-founder of Daksh. Harish, over to you. And you have, 9-10 minutes starting now. Over to you. Thank you.
Thank you, KP. Thanks to the organizers for inviting me to this discussion. What I found most fascinating is the almost commonality in the comments by the three speakers who spoke today. So it does make my job a bit easier, um, because there were not too many discordant notes. Yes, Justice Nandrajog did raise some questions about the functioning of the judiciary overall and the need for specialized benches. And he rightly pointed out, the need for people with diverse experiences deciding cases, and gave the example of experienced people, not necessarily technical people, but experienced people in understanding problems and the application of principles. But both Justice Sridevan and Justice Raghuraman made similar points in terms of whether there is a need for tribunals at all. And I think if I read them both correctly, I think they're happy if the tribunals disappear and the jurisdiction is brought back to the high courts. I have I have about 3 or 4 points to make on the topics that they spoke, and then I will make one additional point about the one point, the subtopic that KP had identified in terms of the specialized regulatory bodies and the need for and how they discharge their quasi-judicial functions. On the points that were made by Justice Raghuraman and Justice Sridevan, I can only say I agree with all of what they said. But what that leads to is what next. And the title of this discussion today is New Frontiers and of Justice Delivery. So, if we are going to say that the tribunalization experience has been a failure, at worst, and at best a mixed bag, then what next for justice delivery is a question we have to grapple with. And I feel that this is where our discussion stalls. Because if we look at justice delivery and the discussions around justice delivery over the last 30 years, I feel that we have not moved forward. We talk about speedy and effective justice, but we have not really come out with action oriented plans. Much of our discussions have been in the form of reports and commissioned reports written by one commission after another. And again, if we look at all the reports, there is a commonality amongst all of them. There's very little differentiation as such. So, how do we move this forward? Where do we, find this breakthrough vision for justice delivery? And there, I have a few suggestions that we need to look into. One, and Justice Nandrajog did talk about this briefly, is the need for technology. Can technology be a tool to achieve or break through some of the problems that we have in justice delivery? So that's the first question, and first question I want to raise. And I think that requires discussion. I think the last 12 months, the last 15 months have shown that technology has been adopted willingly in some cases, and with force in some other cases by the judiciary. But it also exposed the judiciary for what it is, in the sense that it's lack of adoption, because judges realize that they can't sit at home and take cases. They have to go to office because all the files are in physical form, and the machinery that they needed to conduct judicial proceedings still was required, even though the lawyers need not come to court, but the other machinery had to be in place. So technology and breakthrough in technology and our ability to harness technology in judicial process on a day-to-day basis is the key to think of new frontiers of justice delivery. If we don't accept the problem in the judicial process, something that all three judges highlighted in different aspects. They highlighted, if we don't accept that judicial processes that have been going on for the last 70 years, and the last breakthrough in the judicial process happened when the Constitution of India came into force, and not after that. So, what is it that we need to do to change judicial processes? I think that is a key question we need to raise. And we can't keep going back. I mean, the judiciary and all of us, those of us who are associated with the judiciary, can't, our first reaction cannot be that, oh, we are a sacred cow, don't touch us. There is judicial independence, there's natural justice, and we'll quote everybody from Aristotle to the latest Supreme Court judgment. I think we need to be open. So there needs to be an open-mindedness in the approach to this, to finding a solution. Unless that happens, it is not going to change. We will always be inward-looking, and we won't be able to adopt new methodologies. So that is the first thing. In terms of the quasi-judicial points that KP did raise, while I buy the argument on the argument that was made that there's no need for specialization for, say, administrative matters, service matters. In fact, I think now the government is contemplating rent control, special courts / tribunals. For agriculture, I think special persons to decide. All those kind of things. I mean, there's really no need for an extreme level of specialization or sophistication. But if you look at areas like securities or the competition issues, antitrust issues, where there is an element of economic knowledge, specialized economic knowledge and market knowledge that's required for the regulatory bodies. And if you look at the appointments of judges, let's leave the tribunals out for the moment, but look at appointments made to the High Court. There is a uniformity beyond belief. I think you can write one CV of a High Court judge and then replicate it by just substituting the name and where they were born and where they practiced. I think that is the problem. I think, yes, when will we appoint people with diverse life experiences? When will we say that it's okay to appoint, just to take an example, somebody who is got legal experience, got legal qualifications, may have worked in an economic organization or in a regulatory body, and make him or her eligible to become a High Court judge? Unless we do that, you're not going to develop specialization. Unless we are open to appointing people from diverse life experiences, we are not going to be able to reform the judiciary. Because what you have today is somebody who enters the judicial system at the age of 22 or 23 and retires at the age of 65 with very, very little differing life experience of what is required to make the justice system work. And I say this with the greatest of respect to people who have worked in the justice system. But we have proved ourselves short. So it is time to be open to new ideas. And how do we make this? How do we make ourselves to new ideas? I think we have to rely on Tagore, keep our windows open, and listen to new ideas. We are not even listening to new ideas. So this conference is one step forward, and I hope it continues. On the last point, I'll make KP, and I'll stop. On the quasi-judicial authority, I am really worried. And I see how the SEBI, the experiences of the CCI, and to some extent the RBI, I think they are struggling to distinguish between the regulatory function and the judicial function. I think the concepts of natural justice, I mean, look at our writ jurisdiction, right? I mean, the questions are, sort of not even, they're points that will take an experienced judge about half an hour to dispose of. But these are errors that creep in the day-to-day functioning, which leads to an enormous explosion in the writ jurisdiction in various high courts. So unless there is training in these statutory bodies where at the quasi-judicial function, principles of natural justice are brought in, I think we are going to have a serious problem, because pure technical expertise alone is not sufficient for quasi judicial decision making. I'll stop there.
Thank you, Harish. That was an excellent presentation, and sort of also brings back hope. As you said, we need to be looking at processes, we need to be looking at technology, we need to be open minded, we need to be innovative. And thanks also for drawing attention to what is clearly a burgeoning but hugely sort of increasing problem of judicial type decisions being taken by a set of, a hierarchy which is not very well versed with or familiar with fundamentals of functioning of judicial type bodies, the regulatory agency related issues. Thanks very much. Now it's my pleasure to call upon Parag Tripathi. Parag is a senior advocate, a former ASG. Parag, you have, as always, the last word. Your 10 minutes start now. Over to you.
Thank you, Dr. Krishnan. It's indeed a privilege to participate after listening to so many very wise and important suggestions which have come from people with great experience. I have a slightly different approach, and my approach is this: we have a problem of numbers. Our adjudicatory mechanism suffers because we don't have sufficient adjudicators. And that includes the primary adjudicators, which is the formal legal system, the district court, the high court, and the Supreme Court. That is our fundamental problem. There is also the problem that we as a system in the former adjudicatory system try to go for the best, and best becomes the enemy of good. Therefore, you have interim applications which are heard for days together because there is a hierarchy which examines that order in great depth. And so it is not unknown that an interim order will be disposed of by 100 or 150 page judgment. Now, these are difficulties which can be sorted out by the formal adjudicatory system itself, if necessary, by a white paper. These are aspects like, for instance, what is the burden on the adjudicatory system of new laws, like, for instance, the dowry provisions, which brought a huge load on the criminal justice system, the 138 and check bouncing, which brought a huge load. So we have this problem of mismatch of numbers. And only yesterday, a bench of the Supreme Court of Justices Sanjay Kishan Kaul and Justice Roy directed the state and union territories to fill up all the vacancies in the quasi-judicial tribunals within 8 weeks because they have not been filled up. So that's a big problem. There is also another aspect involved in this shift from the court to the tribunal. It's not just a different system. There is an element, frankly, of turf war. The turf war is that in the judicial appointment system, whether it is the High Court or the Supreme Court or indeed even the District Court, the executive has very little role to play. And I'm not talking of this political executive or that political executive. The parliamentary MPs are all united on this. Now, therefore, there is an element of turf war. The more you can take out of the High Court and give to tribunals, the greater is the chance of the role and say of the executive in the appointment process. So that's a very important aspect which we should not overlook. The third aspect, which is of great importance and has been adverted to by my illustrious and distinguished speakers, is the question of domain expertise. Now, domain expertise is, of course, important. Its importance cannot be overstated, but sometimes it may be overstated. And the reason why I say is, please look at our bureaucracy. My belief is that our bureaucracy and our civil servants, that may be an unpopular opinion, is actually quite an extraordinary bunch of dedicated people, just like our judges. You may have bad eggs here and there, of course, you have them everywhere, but they are a dedicated bunch of extraordinary people. And those people work as well in the health department, steel, economic affairs, education, sports. How are they able to handle all that? You handle all that because you have one interaction with your peers. So you check up what are the to do things in this new ministry where I'm working. And also, you have to have, in addition to on the job training, you have to have an introductory briefing. Now, when supposing somebody becomes an ambassador to the US, he doesn't just take a flight and land up in the US Indian embassy in USA and start functioning. He is briefed by the MEA. What is the importance? What are the areas you have to be careful? What is it that you don't have to speak about? What is it that you must speak about? Who are the people you should avoid? Who are the people you should meet? Now, the problem is that as lawyers, we know when one of us becomes a judge, and all the distinguished panelists here have had that great they have been elevated as judges and done an extremely extraordinary functioning as judges. They know that you just change the hat. So today I'm a lawyer. I'm sitting in the bar, talking in the bar room, backslapping friends. And tomorrow I put on the hat of a judge and I maintain that distance. We are used to that. And then there is on the job training. As lawyers, we get paid for making mistakes and we learn. As judges, also we make mistakes and we learn. So that on the job training is inbuilt in the mindset of a lawyer or a judge who becomes a judge, as Harish pointed out, from the traditional track, that is from lawyers, and he becomes a judge. The problem is when you have technical members, and I have found this there's some very fine technical members, no doubt about it, across the tribunals. But I find that they become hesitant and uncertain when they are faced with juristic principles. And that becomes worse when you have senior counsel who are basically bullies wearing a different gown. And they try to bully their way through the argument saying this can't be done, this can't be done. And then they will cite A, B, C, D, E, F, whatever. And I find that the best of technical members feel a degree of insufficiency that can easily be done away with by having a formal introduction to law, which should not last more than 4 weeks, under the control of somebody like Justice Raghuram was, and that is what he did in his term in the Bhopal Academy, to tell them that these are very simple principles. Because contrary to common belief, law is not an ass. Law is established principles which you have to apply with gross common sense. Now, I'll give you one example. There was a matter which went on in CCI about whether cement companies had a cartel or not. Whether they had or not makes no difference. And there was a huge amount of penalty, some 560 crores, which was levied. The way the hearing went on before the CCI was, there were 6 members, 2 went out, 3 came in, the chairman walked in, the chairman walked out. On the last day, the chairman was there, then he went away and he signed the order. Now, what does the appellate tribunal do with such an order? It has to be set aside. This can't be done. Therefore, the problem really on tribunalization is that many times the tribunal members who are technical members are very good in their domain expertise, are unaware of the fundamentals of law, which is something which can be discussed and brought home to them in as little, in my view, as little a time of 4 weeks. So that when they sit there and some counsel comes and tries to tell them natural justice, they'll say, we are aware of it. This is the latest law. Come to the point. How does it apply here? Like any judge in the court would. You would say, yes, Mr. Tripathi, I'm aware of natural justice. How does it apply in your case? You've been heard or you have put in your reply. So that, according to me, is a very important aspect. In addition to how, as was pointed out by the panelists, how you appoint your members, and the members of the tribunal, and of course your judges. The problem which we are facing in India today is a surfeit of litigation, and which requires really not only introspection, because we are well past that stage, a concentrated effort at the level of the formal adjudicatory system, which is the system, of course, headed by Honorable the Chief Justice of India, and Chief Justices of High Court to work out a methodology where best does not continue to be the enemy of good. I had made a suggestion, which is, of course, virtually blasphemous. My suggestion was that in interim orders, all that a judge should do in a suit, whether it is a patent suit, whether it is a trademark suit, or whether it is simply agreement to sell suit, these are the averments in the plaint or the application. These are the replies, paras. These are the 7 documents which I have examined. These are the 4 judgments which I think are relevant. I am now granting the interim injunction. Come up, complete your pleadings, come up for evidence within 6 weeks. The great advantage there is ultimately at the appellate court level and certainly at the level of the Supreme Court, the matter, if there are enough number of senior counsel creating enough amount of confusion, the way the matter is decided is that you start afresh. And the amount of time which is spent at the interim stage is horrendous. Justice Nandajog, because I had the privilege of appearing before him as a lawyer in the Delhi High Court. I didn't have the privilege of appearing before the other 2 very distinguished speakers, though I've heard so much about them. Justice Nandajog always had that view that come and let us decide your suit. Ultimately, you have not come here for an interim order. You come here for deciding of your suit or your writ. Let's decide the basic plaint which you have filed. And that is to be the approach. Now, if that approach happens, then you really don't need so many tribunals. Because what is happening in tribunalization is that the courts are having a surfeit of litigation, and then you pass the buck on to a tribunal, and then after some time you come and say that the tribunal system is not working. So ultimately what you need is a view where you have to fundamentally reform the adjudicatory process, where, as in arbitration, good or bad, you have to be satisfied with the last order, certainly the last order of the High Court, with very limited avenue for appeal. One last thing, because Dr. Krishnan has put his hand across, I understand that and respect it greatly. I've known him for the last several decades, enough to respect when he says this. One last thing is a problem, that when you have more tribunals, all challenges from the orders of the tribunal come up as statutory appeals in the Supreme Court. Now, it has 2 parts to it. We have to reduce it to SLPs, and SLPs are special leave petitions, petition for leave to appeal, and should be treated as such. The statutory appeal, the problem is some judges treat it as SLPs, some judges treat it as something which is higher and issue notice as a matter of course. And I hope that over time we will be able to get over this simple answer, put everything before a tribunal, retain the jurisdiction before the adjudicatory mechanism, which is your fundamental mechanism, that is the court. Yes, as Harish says, make the appointment of judges more broad-based, do so many other things, so that instead of having so many tribunals, you have one concentrated justice dispensation system which is made effective. Thank you so much.
Thank you. Thank you very much, Parag. And thanks again to all the speakers and discussants. We've been actually quite disciplined. We are only about 10-11 minutes behind schedule, which is perfectly fine because that's something we had worked into the schedule. Before, I have one question which has come from the audience directed specifically to Justice Nandarjo. But before I come to that, maybe I could ask Justice Raghuram, followed by Madam Prabha Sridevan, if they have any quick responses, a minute each, to the viewpoints that have now been articulated, somewhat differing from the points that you had made. Justice Raghuram, first over to you, sir. A quick response, followed by ma'am.
Yes, thank you. I respect and concur with Justice Pradeep's observation of the justification for a tribunal. But the fact that we have had giants yesteryears and quite a lot of pygmies now doesn't, as to borrow a felicitous expression from Arnold Toynbee. We live in an age where pygmies cast long shadows. So that's the problem. Uh, in the mainline courts, there is a system of checks and balances, and with substantive exceptions. Your performance, qualitative audit is there of one's performance. Whereas in the tribunals, there is no audit of the performance. Qualitative audit is certainly not there. Quantitative, expectations are there, which could be fulfilled by being a, Virat Kohli, irrespective of the quality of the orders you pass. Disposals, which are euphemisms for bulletins. That's one. Then I found that in a hybrid tribunal where there's a technical and a judicial member, it's been my experience that you have stereotyped qualifications. A person who has been a judge of 7 years, a person may have been a service judge, very great expert in civil and criminal law, and because of that background expertise, even in the High Court, he would have dispensed with areas of criminal and civil law. Then he's sent to let us say, a tax tribunal. It's all Greek and Latin to him. And then there's a technical member who is substantially ignorant of nuances and fundamentals of law, and often allergic to it as well. And when these two persons sit together, the judge either pulls his rank and becomes a disruptor, or he shrinks into a shell and becomes an abdicator. So in either case, justice suffers, has been my experience in the tax tribunal. The judicial member is either an abdicator or a disruptor of the process. And the technical member, without knowing any nuances of law, he decides. Matter goes to Supreme Court, and as Parag rightly pointed out, many judges follow the SLP protocols while disposing of statutory appeals. Some treat it as statutory appeals, and then there's a mix-up there. These are the problems with domain expertise. It's not merely expertise, but 4 weeks training. I have done some training for non-judicial components of tribunals in the academy, and I found that many had very deep notions and entrenched allergies to the process of law. So,
Thank you, sir. Thank you. Before I call upon Madam, there is a question that I thought I will add to the list of issues that she may want to address. How pragmatic is the situation when a tribunal like TDSAT, Telecom Disputes Appellate Tribunal, is now also mandated to deal with issues that were earlier with the Cyber Appellate Tribunal? This combination of subjects, there are a couple of questions that have come. So, ma'am, in response to other points that have come, if you could also deal with this question, over to you.
See, we are talking of justice delivering institutions. Two kinds of justice delivering institutions, courts and tribunals. Mr. Harish Narsappa mentioned the lack of awareness of something basic like principles of natural justice that really cuts at the judgment making. Now, Justice Nandrajog spoke of need for specialist knowledge. I would like to say that in the famous Novartis case, I was told by Professor Shamnath Bashir, who appeared as on invitation as an expert amicus, that on the first day, I believe Justice Aftab Alam said, "We are unfamiliar with the subject. Can you please explain?" And within a week, Justice Aftab Alam was new. It only requires application, but these principles of justice and the creation of justice is something that I feel being in the court enables that. And this is something that I've repeated often. There is a judgment of Justice Chinnappa Reddy in a Monsanto matter. Now, I will only talk of intellectual property because that is what I have been familiar with. And it is so brief, and better than that, no specialist judge can do. So if it is, I mean, a cyber, I mean, that jurisprudence requires specialist knowledge, and if if it is needed, you ask for experts to help you. That is all. Nobody can be an expert in everything. For instance, in IPAB, I had a technical member. He was a graduate in one discipline. He cannot be a graduate in everything. So he too needed to learn about if it was electrical engineering patent. So I really think the improvement of the courts, the enabling of the courts, and we are still stuck with court management techniques which are decades old. I think that should improve. And then the need for what I hate, the word quasi-judicial forums will will disappear, because we need justice. We don't need quasi-justice. That is
Well
what I
said.
want when I go to a tribunal. I want justice to be done.
Thank you, ma'am. Pradeep sir, a quick response to this question: is the National Judicial Service a possible answer to the problem of manning of the tribunals? This is a question that has come from a couple of people. A quick response from you, and then I will hand over the mic to Sunanda from INET for concluding remarks. Over to you, sir.
When you say a National Judicial Commission, are we trying to say that the recruitment to the district judiciary should be centralized? Is this what the person
I
who put the question
suspect,
had in mind?
he hasn't elaborated, but it's a law student who has asked, in the context of judicial officers for regulatory authorities and tribunals. So I don't think the question is really directed at the judiciary itself, but for,
Okay,
say, members of ITAT,
right.
SESTAT, and bodies like that, and judicial positions in regulatory authorities. That's the sense I make.
Yes, I would suggest that since we have to find a breakthrough, and the breakthrough has to be outside the existing system, because all permutations, combinations within the system have been tried and they have failed. So we have to look at people who, whether they were as judges, have they dealt with a wide variety of litigation, and is their approach correct? Let me give one little example. We had this issue of the patent of that anti-cancer drug, irinotecan chloride, Cipla versus Roche. The real dispute was that whether the lattice structure of the same molecule would qualify as a distinction between a new compound and a new substance. Nobody was in disagreement that both the parties had picked up the same molecule, having the same molecular structure. The innovativeness was of one finding a lattice structure which was stable, and the one who created the molecule could not find a stable lattice structure. We had specialist lawyers, we had patent experts, and the evidence of chromatographic profile of the two compounds which had to be the same. And there was no evidence of the lattice structure at all. So the point which I was saying was, and that is where, when we talked of the conflict which comes when we have a technical and a judicial member, it's just that the judicial member would know the structured approach which law warrants to pick up the exact pleading and look at the response. Is it a plea of demurrer? Is it a plea of total denial? Is it a plea of confession with avoidance? In spite of there being so much clarity in what is the four kinds of pleadings, every time we see in courts replication, rejoinder, I just come and tell the court, of course, what this guy is saying is correct, but he's not entitled to relief. Yet there is a rejoinder. So the problem lies somewhere in the application. And I don't think so. You need judicial training. You don't need judicial training in the application of a structured approach. It's all commonsensical. If there was no law of evidence, would we not know which fact is a relevant fact? This relates to conduct. This relates to preparation. This relates to the commission of the act. This relates to the proximity of the time and the place. We don't need all that. We just don't need all that. It's too much of a hullabaloo. So therefore, to just wrap up the answer, yes, we need that to pick up the right people. And that is where actually Justice Raghuraman also said, we cannot look at the giants of the past when we have pygmies. So it's something like saying, the cages which were occupied by the lions, if they are occupied by the monkeys, then you better be ready for monkey justice.
Thank you, sir. It's a very forthright and absolutely sort of clear answer. With that, it's my privilege to hand over the mic to Sunanda Nair of INET for concluding the proceedings. Sunanda, over to you.
Hi everyone, I'm Sunanda Nair Bidkar and I'm the Director of Strategic Planning South Asia for the Institute for New Economic Thinking, INET, New York. And I'm also a member of the steering committee of the LEPC, along with Dr. K.P. Krishnan, Ajay Shah, Ila Patnaik, Somshekhar Sundaresan, and myself. So on behalf of the Institute for New Economic Thinking, INET, and the Institute President, Dr. Robert Johnson, and the members of the steering committee, I wanted to take a few moments to thank each one of the panelists. Thank you for your time, and thank you for this very robust conversation. As most of us who have been in the space of law know, the issues raised are complex, has been long debated upon, and much has been written about it too. But I sincerely hope that the audience today got a different perspective and found that the ideas were different that were raised here, or that came out over here, so that there could be a difference made going forward. Briefly, the Institute for New Economic Thinking, INET, was founded in 2009 as a nonpartisan, not-for-profit institution in the United States to meet current as well as future challenges around the world. INET commissions research, convenes fora and discussions very similar to this one. It develops curricula, and it also nurtures and inspires a whole section of young scholars through their Young Scholar initiative called the YSI. In 2016, the Law, Economics and Policy Conference, LEPC, was launched by INET here in India. It was structured as smaller in-person discussions at the Habitat Center in Delhi. But it is only in 2021 that we have actually brought this onto a virtual platform as multi-capsule series, in a multi-capsule series format. So with that, I thank each one of you for joining us, and I hope to see you again at the next capsule soon. Bye.